Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was out on bail with court approaching. Let's see here. I have to go to court next week for a case of assault with a gun. I'm out on bail, but I'm afraid I will be arrested when I go to court. Okay, well, first of all, let's talk about the assault with a gun. This is an assault, obviously an assault with a deadly weapon. It is a felony here in the state of California, under Penal Code Section 245, parentheses A, parentheses 1, that carries up to 4 years state prison. Plus, because the use of a firearm, it will be a gun enhancement, which usually could increase punishment anywhere from 1 to 3 years, depending on circumstances. Now, here's the deal. When it comes to assault, remember that you don't actually have to physically touch somebody to assault somebody. That's why you probably have heard on TV assault and battery, and people use it together, assault and battery. They're two separate things. Battery is the actual touching part. The assault is putting somebody in apprehension. The fear, that feeling of fear, I have been assaulted, that feeling of fear, that's the assault. For instance, if somebody whacked me in the back of the head, bam, I wasn't assaulted. Yeah, I was battered, but I wasn't assaulted. Now I see the punch coming. Oh my God, here it goes. That is that fear, that sense of fear. He caused me or she caused me. That sense of fear, that would be an assault under Penal Code Section 240, and if it's with a deadly weapon. And by the way, what deadly weapon does not have to be a gun. It could be any solid object to kill somebody with. You could whack somebody with a chair, a bat, a heavy stapler. That's a deadly weapon. Any solid object is basically a deadly weapon. You could theoretically kill somebody with an iPhone if you hit them repeatedly with it. So that would be a deadly weapon depending on how you use it. Now, the concern you have is whether or not you're going to be arrested being in court. You could be, even though you bailed out. Now, usually if you bail out, you posted bail, you had a $20,000 bail, $30,000, $40,000, whatever it was, and you posted bail, there shouldn't be a problem. You shouldn't get remanded. Usually when in court, they usually call it remanded. Outside of court, they call it arrested, but it's the same thing. They haul you in. But here's the deal. What I would recommend that you do to alleviate your fears, or at least to minimize your fears, is to check the bail schedule in the county when you were arrested. This is important. Let's say the bail schedule for an assault with a deadly, I don't have it memorized, but let's say the bail for an assault with a deadly weapon, a 245A1, let's just say hypothetically it's $100,000. I think it's a little bit less, but let's say it's $100,000. And let's say for some weird reason they had you post a $30,000 bail. Now, as long as the DA doesn't jump up, the judge will be like, okay, well, $30,000 bail, whatever, he's here, his family's here, whatever, no big deal, and he'll just arraign you and give you a new court date just so that your lawyer could study the evidence. But the DA could jump up and say, hey, wait a minute. This man posted bail, but it's way below schedule. It's supposed to be $100,000 and he only paid $30,000. I want him remanded for the balance. The judge would look to me at that point and say, counsel, you got anything to say? I'm like, well, look, Your Honor, the purpose of bail is so that somebody, is ensuring that they're going to come to court. My client here lives here locally. He's worked here for 25 years. He's not a danger to the community. He doesn't have anything else on his record. His whole family is here. Blah, 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 blah. If you remand him, all you're really going to be doing is imposing an undue economic burden on my client's family, because he's just going to post the bail that very day and then be released, and then we're going to be back to we're going to be back here in square one again, so why bother? Of course, the DA could counter and say, well, yeah, but then it's not the same risk level, because it would be a $20,000 bail versus a $100,000 bail, and so it would go back and forth. Well, a $100,000 bail requires collateral, whereas $20,000 bail doesn't require collateral. It'll go back and forth, but that's really the only time when there could be a situation where you could be remanded. Now, what I've had clients do in situations like this, and we've had this happen a few times where we thought the bail was a little too low, we would sometimes have a bail bondsman right there on standby. We would have the bail bondsman right there on standby. So not only is it our office and our client, we would have the bail bondsman and we'd say, Your Honor, we would obviously give the same pitch to the judge and say, hey, look, it makes no sense. It's just going to be an economic burden. It's a waste of time. He's going to be here. He lives here locally. He's lived here. He's never had a problem with the law, blah, 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 blah. In the event that the judge says, I don't care, I got to remand him because it's too much, I say, well, wait a minute, Your Honor. Bail bondsman, blah, 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 is here right now. He's willing to assume the difference of the bond. He's willing to sign for it right now. Can we just go to the clerk's office and pay for it right now and then come back up, and then you don't have to bother remanding the client? The judge being like, okay, fine. So yeah, if you're really that paranoid, have a bail bondsman there. It'd probably be a good idea. But that's only in a situation where you've checked the bail schedule and you're like, whoa, I paid only $20,000 for something that should be $100,000 or more. At that point, then I'd be worried. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross and Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was organizing dog fights. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.